So good morning, good afternoon, everyone. Welcome to the WR Immigration End of the Year I-9 cleanup. We're happy to see you all today, kind of sort of see you. We're glad that you're here spending some time with us. And we're going to get started, just go over some of the preliminary information. So again, legal disclaimer, this does not constitute specific legal advice. It's for informational purposes only. And if you would like some legal advice, please feel free to reach out to an attorney. We have our firm, WR Immigration. We're a top-rated immigration law firm providing strategic and client-centered services. And we do specialize in providing high-touch approach with innovation and technology. So we're very happy to have you here today. I'm Kimberley Robidoux, partner in the San Diego office of WR Immigration, and have been in the employment immigration world for a couple decades. So have been around the block a few times. And we have Josune Aguirre Gamez with us, who is a senior associate located in our LA office.
Hi, y'all. Glad to be here with you.
Right. So today, for our end of year cleanup with I-9s, we're going to focus on Form I-9 extension of the current version, which you need to know, the I-9 audit, are your I-9s in good order if ICE were to come knocking at your door, and combating inadvertent discriminatory practices when using electronic systems to screen and hire applicants. So we'll dig into the first one, which is the current version of the Form I-9 has been extended. Whoop, whoop, right? We're all excited about that because it was expiring at the end of October. That is on one of the corners of the form. So on the bottom left-hand corner, the Form I-9 with the date 10/21/2019 that has an expiration date of 2022 is still valid. So there is not a new form out yet. The Immigration Service did do a notice of proposed rulemaking with a new version of the Form I-9 based on what the information they were collecting, as well as some information that they provided. They seem to be very focused on going back to the one-page form. So for those of you who were around when we had the one-page form, it was the most complicated one-page form when it comes to immigration or any probably area with compliance. So keep using the form that you're using as long as it's the one that is valid until October 31st, 2022. The new version of the form will be coming out. There's some collaboration going on with the agencies, the different agencies internally, to see how that version of the form is going to work. There also has been some speculation about whether or not this current version of the form is going to be extended until there may be a new process that allows virtual verification of I-9 identity and work authorization documents. So what we've seen the government allow for COVID-19 flexibilities for virtual verification in very limited circumstances, the government is looking into some type of virtual verification process that could be utilized by employers in the future. So there has been some talk about, will this current version of the Form I-9 be extended until a new virtual verification process comes out? We don't know. We wish we had all the answers, but based on our involvement with the Immigration Lawyers Association Verification and Documentation Committee and in liaison meetings, they are still working on that particular notice of proposed rulemaking and just kind of understanding where they're going to go with virtual verification. So no news out on that front yet. So just stay tuned. Until then, continue to use the Form I-9 that expired October 31st, 2022, but remains in existence. And that's the valid version. Okay. So we're just going to go back to a little bit of basics, right? Who completes the Form I-9? Form I-9 is completed by citizens, nationals, and non-citizens, right? U.S. citizens include persons born in Puerto Rico, Guam, the U.S. Virgin Islands, and the Northern Mariana Islands. Also, the nationals are United States, include persons born in America, Samoa, including Swains Island. People who are exempted from having to complete the Form I-9 and provide their documentation to prove their identity and work authorization are those employees hired before November 7th, 1986. As my years progress in my career, the fewer employees I see that were hired before November 7th, 1986, but there are still employees out there that don't need Forms I-9 completed for them. Also, we don't need Forms I-9 for casual domestic workers, for independent contractors, if someone is providing labor where they are employed by a contractor providing contract services, so employee leasing or temp agencies, and then those who are not physically working on U.S. soil. And what that means is, let's say that you have someone who is on your U.S. payroll, but they are physically providing services and doing their job in Portugal. In that particular circumstance, even though they're on your U.S. payroll, they don't need authorization to work in the U.S. And because they don't need authorization to work in the U.S., a Form I-9 is not needed for them. So just a couple things to keep in mind for that with completing the Form I-9. A couple of the other sticky issues that we see employers get into trouble with sometimes is the timing issues, right? Section 1 of the Form I-9 is completed by the employee on or before the first day of employment for hire. So you can have a policy in place where you send out, if you have an electronic I-9 program, or you send out the actual hard copy of the Form I-9, if your process is to have all employees complete the Form I-9 Section 1 before their first day of hire, when you send them the orientation package, that's permissible, but they have to complete it before the end of their first day of employment. Then we have, what is the employer required to do, right? So the employer completes Section 2 of the Form I-9 within the first 3 business days of the first day of work. We usually refer to this as the Thursday rule. So if an employee starts work on a Monday, the end of the 3rd business day would be Thursday. So you kind of have 4 days if you want to think of it from that perspective. But if you don't complete the Form I-9 on time, it is a timeliness error that cannot be corrected if you were to be audited by ICE. But it's better to complete it late than to have never completed it at all. And then with our Section 3, updating and re-verification, that needs to be completed when someone's work authorization needs to be updated. So if someone's employment authorization document card expires on December 7th, then you need to make sure that you re-verify their work authorization and complete Section 3 by the end of the day on December 7th. Right? So those are some things to keep in mind when you're thinking about completing your Form I-9. Now we have page 3 of the Form I-9, the list of acceptable documents. It's actually called the lists of acceptable documents. I had to go back and verify that because it looked odd to me, right? But it's the list of acceptable documents because we have 3 lists. We have list A, which covers identity and work authorization, either within one document or a combination of documents, or the individual can provide one document from list B plus one document from list C. So there's what we have here. You see the lists. So there's documents specified in A, documents in B for identity, and documents in C that are just work authorization. We call it, in the immigration world, we call it LOAD, lists of acceptable documents. And we've done this process in our committee to actually look at what documents are acceptable for identity and work authorization purposes. And the documents that you see on this list is incomplete. It is missing probably close to 50 other documents that may be acceptable by employers to complete the identity and work authorization verification for new hires and for re-verification of someone who already has work authorization. So for instance, you may have heard that USCIS is significantly backlogged with some processes, especially issuing those EAD cards, the employment authorization document cards. So there's automatic extensions that are available in certain categories. That is not listed on this load. So there's a lot more out there. And the place to look, we'll include resources slide at the very end of our of our discussion today, but there's the M274 Handbook for Employers. There's I-9 Central online. There's an immigration attorney, and there's also IER, Employer Hotline, and IER is Immigrant Employee Rights section of the Department of Justice. So those sources combined, primarily the Handbook for Employers and the I-9 Central, is where you're going to find these additional close to 50 documents that are acceptable that are not on the load as it is printed today. All right, moving on, we're going to talk about just a little compliance documents and retention. One thing that people get confused about sometimes is rehired employees, right? So if you rehire an employee within 3 years of the date the previous I-9 was completed, you can update Section 3 of the Form I-9, current version of the Form I-9. So if the individual was rehired within 3 years of the date that the previous Form I-9 was completed, you want to look to see, is their employment authorization valid? If it is yes, then you want to complete Section 3 with just the rehire information. You want to make sure that you complete that on the new version of the Form I-9, okay? If the employment authorization is not valid, you would either complete a new Form I-9 or you can do Section 3 of the current version of the Form I-9. Okay, so those are for rehires, but always remember that you want to be using the current version of the Form I-9. The other thing we want to talk about with retention is how long do you have to keep the I-9s, right? So the I-9s that you have in your possession, if ICE comes knocking at your door, you're going to have to turn them over. They're in the subpoena of what's being required. So when can you get rid of I-9s, especially those that may not be completed 100%, and you don't want to have those because of potential fines? Always remember, you must have an I-9 on file completed for every active employee. So when we're talking about retention, it is only for terminated employees. Terminated employees only are we looking at the retention rules. If the employee is still employed, you must keep their I-9. I know I repeated myself, but I've had come into contact with companies that have purged the I-9s improperly, and I don't want you to do that. So retention, think only for terminated employees. So you must retain the I-9 for a terminated employee for 3 years after the date of hire or 1 year after the date of termination, whichever is later. So we have examples here about when the person was hired, when they left, what the 3 years is after, the 1 year after, and then we have our date at the end of our formula. You know, we have our math equation here, and we have our retention until. And you can put that retention date, if you're keeping hard copy I-9s, on the top of the Form I-9, and move that I-9 for the terminated employee over into a binder that says terminated employees, and you can keep it in order to determine when you can actually purge or shred that I-9. For electronic I-9s, there's each electronic I-9 software system has a different process by which you can keep track of what needs to be terminated, right? And then comply with their electronic software rules and the electronic I-9 rules as well. So on our next slide, we have a chart here that we pulled from the Immigration Service. We didn't create this. This is actually the Immigration Service. However, we really, really like this because it kind of takes the math out of your head, and you can fill in everything here on the chart and actually clip this, staple it to the Form I-9 if you choose to do so. Or again, you get your final answer of when the document can be purged, and then you write that on your Form I-9. So this is one of the cheat sheets, so to speak, that a lot of employers use. And this really kind of goes in for the paper I-9s if you're going to keep it attached to the I-9s. But it's a helpful guide so that you can understand when to purge the Forms I-9 for terminated employees. And why would you want to do that? Well, if ICE comes knocking at your door, and that's Immigration and Customs Enforcement, and specifically Homeland Security investigations, they will come to sometimes randomly pulled employers, or sometimes driven by a complaint, come knock on an employer's door and they say, we want to see your forms I-9. They can ask for just the current employees, or they can even go to terminated employees. So for those terminated employees, if you purge the forms when you can, then you don't have to legally turn them over because they're gone and they met the requirement. So Josune, why would employers want to go through a process that we're talking about to clean up at the end of the year, to kind of look around what they're doing for their I-9s? I mean, what's the big deal with an audit?
That's a great question. So the big deal is if ICE does come knocking on your door and ask to see your I-9s, and there's been no upkeep at all, you have no idea what kind of liability you're handing over. And ICE is not, too kind in the way they interpret how to conduct fees, right? So it could lead to a lot of errors. If we can go to the next slide, sorry. After. So, we're seeing a matrix of I-9 fees that really doesn't make sense to us, but makes sense to the immigration officials because they get the most money out of it, right? And so what we're seeing are civil fines. What we do see in certain circumstances are criminal penalties when there is a pattern or practice of violations, mostly knowingly hiring those without work authorization. But a big one is debarment from government contracts, right? So even if there's some finding that there's errors and there's debarment, this is made public usually. And so not only could it affect that one contract that you had that required you to maintain, in compliance, you may find that other contracts may be at risk because they see that you violated, certain compliance requirements. And, there's also employment issues, right? A court may order that the employer was liable for back pay and the individual, was discriminated against. So there's various penalties that can happen. And those are some things that you may want to look at when determining whether you want to protect the company from liability. And so when we discuss with our clients, and there's the idea of whether we want to do a self-audit or an internal audit to determine whether there's a fundamental issue across the board that could be corrected, or just make sure that everything's above board and compliant, we do discuss the risk. And the risk is right now, ICE really wants to bump up their enforcement. They are in the process of clearing up their backlog. They've done a great job of that in 2021, 2022. And now we're seeing that they're already in the process of issuing notices of audits. So, some services or some lines of business are at risk, or more at risk than others, right? However, it can be random. And so just knowing that the, intent right now of the government is to increase enforcement, it's likely a good idea just to make sure everything's good and above board. So civil penalties. This is where, again, the matrix may make sense to the government, but I still have a lot of questions. And for basic I-9 paperwork violations, so that can be just missing a box, right? That can be between $252 to $2,507 for the first offense, right? And, when we're looking at uncorrected technical errors, these are things that could have been caught during an internal audit. And even if they were, an error, correcting it shows good faith in trying to maintain compliance, right? So that's something to think about. So, and the violations or the fees only continue to go up. But if we can go to the matrix in the next slide, I think it generally makes sense, right? 0 to 9% would be 252. 50% or more would be 2,000. So we're looking at, percentage of violations. But Kim, that's not really how it works, right? They're looking at, let's say, 100 I-9s and 90 of them have the same error because HR was not trained correctly. What are we looking at on that end, right? And that's going to be considered 90%. And so for, the offense, it's going to be 2,131 beginning, right? So that's just wild.
And that's just for one I-9, as you're saying. I'm working with, a company where they have pretty much the same mistake on over 20 forms with employees of a little bit less than 30. So that's 50% or more of their Form I-9s have problems, which the base fee for each I-9 is $2,131. And you multiply that by the 25 forms that have mistakes, and we're up to a significant fine.
Yeah. Mm-hmm. Criminal penalties, we don't see this too much, but it does happen, and it's with, engaging in a pattern or practice of hiring those without work authorization. So there are, criminal penalties that are up to 3,000 or more and can go into actual sentencing, jail time. So not fun. So, the first step to do is ask what's the purpose of the I-9. You want to make sure you avoid any appearance of discrimination, right? And I think the second step is to probably make sure that there's an I-9 for each employee. This seems probably basic, but you'd be surprised. There are some that may have gotten lost in the transfer of how I-9s were retained, right? There may be just someone who was hired and it just totally, slipped under the cracks, and there's just, no I-9 on record. But, you want to then determine the scope. So are we doing all I-9s, current and those in retention? Are we just doing all employees, or are we doing just a sample to look at, if there's any fundamental issues, right? And when we're doing a sample, we have to be very careful on how we select those, because we need to avoid any even appearance, right, of discrimination in how those were selected. So you won't go in and say, hey, I'm going to get 10 of my foreign nationals, right? Or I'm going to get only, 10 of my US workers. We want to take a look at how we're looking at that. And our recommendation is always to be as random as possible, get a random 10. And if it's being, if it in the discussions internally have been discussed, you understand the purpose, you understand the scope, and the company has just determined this is, a business, decision that makes sense, because some may say, hey, we're overwhelmed. Like, we just don't have the capacity or the personnel to be able to go through these I-9s, or we just can't hire outside counsel to do this at this time. It may not make sense, right? We have to look at how risk adverse we want to be versus our reality, right? Whether we have the ability to do it. But let's say we do, right? And we go through with it. We do need to communicate it with employees to make sure, again, it's, if we have to make any corrections, especially, looking at section 1, you can't correct it. You'd have to have the employee correct that, right? It needs to be communicated in a way that avoids discrimination, retaliation, any even appearance of discrimination. But we also want to make sure that there's, clear steps and a clear, outcome for this audit, which is to make sure I-9s are corrected and how to correct those or omissions found on I-9. So some steps: gather all forms, ensure that there's a form I-9 for every employee, like we discussed. Also, one of the first things that I see in audits when ICE is knocking on the door is show me your pay stubs, or show me your pay records, right? And show me the I-9s to correspond with that. So, you want to make sure that you're looking at who's on payroll and who needs an I-9, right? Because sometimes I think we get confused. We may think somebody's a contractor. We may think, an owner is not subject, but if they're on payroll, right, they would need an I-9. And then we got to remember, the additions, the form I-9. So sometimes we can see that it was on the wrong addition form, right? We need to make sure that, the current employees have completed all sections, because again, just omitting a section is in fact an error and would be considered a violation. And, correcting the documents, we always need to have a paper trail of it. So if it's, or, an audit trail. So if it's on paper, we would initial it and date the sections that we are correcting. Now, most companies are now using electronic forms of I-9 and how they retain the I-9s. So most will have an audit trail. So it would be corrected. So when the employee or HR individual logs onto the system and corrects it, it would have the individual's name, the date, sometimes the time as well, which is nice, and informs the correction. So another thing is, a lot of times we're not purging as we should. And if ICE is asking for all I-9s and we hand over many that don't need to be there, we're just opening the door to additional liability. So let's make sure, we've purged the ones we can.
Josune, can I ask you what you've seen, and with respect to auditors, if an employer completes the Form I-9 on an incorrect addition? So let's say that the current, edition is out right now, but they used the edition from 2015. What have your auditors been doing that you've seen in the area? Because I know some field offices are a little bit different, but overall, what have you seen?
I think we're lucky with our LA offices, which has been my experience mostly. And they've been like, hey, the information is the same. It's not like one of the old forms where some things may not have been bifurcated, for example, or asking for additional information. And so they've said, this is a warning, right? Make sure moving forward. And those have been with cases that, they haven't, updated the actual form edition. And then we've had some who have done internal audits and asked their individual employees to correct and update with the correct form edition. And again, the officers have just been, okay, great. But again, this is a warning. So most of LA officers we've been really lucky with, and they've been pretty understanding where they've just wanted to educate the employers and just go off with a warning.
Yeah. And we've seen it in
San Diego.
Yeah, well, in a couple other places, and when we've spoken with, liaison, a lot of the auditors say, if you're doing an internal audit or you notice before you turn documents over, create a memo that says, we understand that this is the wrong version. We're sorry, we won't do it again. And that happens either, when I'm working with companies gathering their I-9s in response to HSI, we'll put that memo there. And then other times when HSI is looking at things, they'll tell us, hey, these are on the wrong version. Don't do new I-9s for these employees, just update with a memo. But again, it's if you're before, doing a new I-9 for any employee for whom you already have an I-9, right, just need to talk to an attorney, because there could be potential issues that could come up where the employee thinks that they're being discriminated against.
Exactly. So LA has been pretty great with their officers, but I think they do expect those memos, right? For most things, internal audits, even, they want to see a memo as to why, they have multiple I-9s that have been corrected on a certain date or a certain time frame. And so they do want to see internal memos that kind of give that paper trail or that, audit trail, right? It's all about documenting and making sure you're in compliance and ensuring that there's no appearance of discrimination. I see there's a question, if an employee is missing an I-9, what's the best step? The best step is to have them complete it. It's never too late to complete an I-9. especially if you've never been audited yet. So that's great. You're going to have it. You can include a memo as we're discussing saying, while conducting an internal audit, it was discovered that there's missing I-9 for this individual, and it was completed at a later time. Well, look at there. Never too late to complete I-9s. How to correct mistakes and omissions, definitely discuss with an immigration attorney if you have specific questions, but there are guidance. Immigration, has provided guidance on what to do, but it's never delete, never white out, never black out, and never backdate. You want to potentially either cross out information, initial and date, or cross out incorrect information and update it. Or, immigration has said if it's just completely, a mess, then you can complete a new I-9, but also include that memo stating that, documents didn't relate to the individual, or everything was just in order. It was just too disorganized to then be able to complete a correction on that I-9. And so, Kimberly, when completing a new I-9, because the original was just disastrous, what do you see as far as officers? I mean, I think they're pretty understanding if it's clearly a mess, but I think they do prefer a correction on the original I-9 if possible, right?
Right. They like to see that correction. Electronic I-9s do the correction so you have the audit trail, but if it's a paper I-9, or if it's too complicated, you can always print from the electronic, do the corrections on the hard copy, and then upload into electronic. But if it's, like you said, if there's a lot of errors and it's super confusing, as long as it's documented, as long as the employer has a memo that says, we noticed a lot of errors on this Form I-9, we've completed a new Form I-9. Most of the auditors with whom we've worked, even though that they've seen, okay, this was I-9 was completed timely initially, and then a new one was done because of all the errors. I haven't seen companies fined for that particular circumstance.
Yeah. That's great. All right, the fun stuff. Not to be too doomsday. This is all just stuff to make sure that we're compliant and, less risk adverse, and just ensuring that, we are understanding the climate that we're in, right? Right now, what we're seeing is a big push on the government to look at these electronic systems used for job postings, right? And Kimberly, with these, there's a back end and a front end for employers, right? There's the, questionnaire to include things in, which may not always reflect what's really posted on the job posting. And so it's kind of a bit of a twofold, review for employers to look at, because what the government is doing is they're pushing to see if there's any reason, any appearance of discrimination, to then go after those employers, and they are going after them as much as they can. This is a big priority for them. It's been discussed in our liaison meeting. It was very clear, and IAR is very clear that, there's no showing of animus or hostility requirement, right? So, hey, if you're the employer and you're like, hey, I just completed this questionnaire on this online job posting, platform, I had no intent to make, protected individuals confused on the job posting. They won't care. There's no requirement of animus or hostility. It could just be a technical error, and that is sufficient to then fine the employer. So a big reminder here is, don't just take it for face value. Like, hey, this is a big, platform. It's obviously compliant. It may not be. So it's unfortunately, on our shoulders, right, to then review that and ensure compliance. So.
Right. So we're now getting into the area of Department of Justice's Immigrant and Employee Rights section. And they exist, and they have existed for a long time. They used to be Department of Justice Office of Special Counsel for Immigrant and Employee Rights. And what we were just dealing with the I-9 audits is under USCIS is the one that creates the form and all the instructions and the guidelines. And then the enforcement arm is Immigration and Customs Enforcement, Homeland Security Investigations, right? HSI. They're the ones that go out and hand the employer their I-9 notice of inspection. You have 3 days. And so when we're talking about doing this internal I-9 cleanup, with all of the activity that we've seen in the last couple of years with IER, it's really important, as Josune was talking about, having a plan in place and a process to do your internal I-9 check. If you're doing it on your own, or if you're working with an attorney, to ensure that you create that process with the attorney, because you don't want to have any kind of appearance of discrimination, which can happen, right? If an employee thinks that they are being selected because they have an accent, or they are from somewhere else and they're not white. So there's a lot of things to think about with doing an internal self-check, right? So that you're prepared for when ICE might knock on your door. And there's this discrimination piece that's hanging over there as well. So I'm going to talk a little bit about over-documentation in terms of the I-9 context, and then we're also going to talk about some of the software stuff, for lack of a better term, that we're seeing in terms of technology and investigations by IER. So IER exists in order to look at and enforce any kind of compliance issues where there is prohibited behavior by an employer. So the prohibited behavior is citizenship status discrimination in hiring, firing, or recruitment or referral for a fee. That's where we're going to look at our technology. National origin discrimination in hiring, firing, or recruitment or referral for a fee. IER gets involved with company sizes of between 4 and 14 employees. Greater than that, it's the EEOC. There's also the third prohibition, which is document abuse, which is unfair documentary practices during the employment eligibility and verification process, which is the Form I-9 process. And then with any of these, any kind of retaliation or intimidation. And this is where some employees can actually call the hotline for IER and say that they feel that they've been retaliated against because now they're having to complete a new I-9 and their manager told them that they did a bad job, right? So reason we need to be careful about this. With the I-9s, we're looking at the document abuse, right? So with document abuse, HSI, they don't care if they're looking at the Form I-9 and see that the employer completed A, B, and C for the process, right? Hey, we got all the documents. We're definitely proving that this person has, what their identity is, and they have work authorization. HSI is like, it's been completed properly. Are there any mistakes? We're looking at mistakes. IER is the agency that looks at, you over-documented. Does that mean that you asked for specific documents? And did you ask for specific documents because the individual checked the box that they're a lawful permanent resident? They gave you a driver's license and an unrestricted social security card, but you, the employer, said, I need to see your green card. I need your permanent resident card. You check that you are a permanent resident. They turn it over. Okay, yeah, I have it because I have to carry it legally with me at all times. Here's my permanent resident card. That's completed. All 3 lists are completed. That can be document abuse. And it's something that IER may investigate. The thing with IER is once they have a complaint, or they could also have information relayed to them by HSI based on their memorandum of understanding, where HSI can say, hey, we just did an audit and we noticed X, Y, and Z. You may want to check out this employer. There could be discriminatory practices that are ongoing. If IER goes in to investigate, they are very, very particular. They are very much an investigation arm of the Department of Justice. They will dig in to everything. They are, for having been through a few of these, they're incredibly thorough. They ask for a lot of documents. They interview not only the individuals that complete the I-9, who review the I-9s, but they can investigate employees, management, C-suite, everything. Ask for a lot of documents, way more than we might see, actually, that we do see in an I-9 audit. So it's to be very careful, right? Because of this discrimination practice. And as Josune said, it doesn't have to be intentional. And that's one of the things that has been very difficult for us as attorneys and also for our clients to understand, that this isn't a very forgiving area when it comes to individuals. Is there any kind of pattern of a discriminatory practice, right? Where you're asking for documents based on an individual status and not based on just proving that they have work authorization. So that's IER. What they don't want is for an employer to request documents before they hire or during an interview. And again, that can come across as, well, we want to see your documentation to make sure that you have work authorization because we don't believe you, right? So, or you have an accent, so you must need some kind of documentation. If you, as an employer, tell an employee, specify what documents you're going to accept, that's not good either. You want to provide the list of acceptable documents to the individual and say, you choose. There is the document dump that a lot of you may be familiar with, where you ask for the documents, the person's like, here you go. Here's like 5 documents. Here's my student ID, my driver's license, my unrestricted social security card, my birth certificate. I was born in the US. Here's my US passport. You choose. Nope. Under this system, the employee has to choose. And we know that it can be very difficult, especially with those documents that are not acceptable documents, and employees get confused about what they need to provide. We as attorneys can get confused as well with all these recent developments with documents that are used now for Afghanis and Ukrainians to prove their work authorization. So you want to help, but it has to be clear that you're not telling the individual what to provide. Right. The same thing with, you can't refuse to accept documents that appear to be valid on their face. If it's pretty clear that it's fraudulent, we've seen social security cards where on the back, Social Security Administration is in Spanish. Yes, those do exist. And it's not a document that's valid. So you can say, I can't accept this document. But if it otherwise looks reasonable on its face, you can't accept it. You're not law enforcement. So you're not held to that higher standard as law enforcement is. And one of the things I also talked about is someone checks off that they're a permanent resident, but they provide you with a driver's license and an unrestricted social security card. You can't ask for that green card to prove what they selected in Section 1. It's very important. There's a distinction that I want to talk about before I move on to the next slide, is just, this request documents before hire during the interview. For those of you employers that do hire foreign nationals and you have a business operations reason to want to know what is their status, right? Do I have to, if they're an H-1B, how much time do they have left? So, where are they in the green card process? There might be business related reasons that is also together with financial reasons, right? It costs to sponsor individuals in certain circumstances. So in those situations, requesting documents before hire may be acceptable, but we want to leave you with the questions that you can ask without stating which one. Are you a U.S. citizen, non-citizen, national, lawful permanent resident, asylee, or refugee? And if the person says yes, well, we know that they're a U.S. worker, they're protected. So then you just go on. If they say no, then you can ask, will you now or in the future require sponsorship for employment visa status? And if they say yes, they do require sponsorship. As long as it's very clear what you're asking and why you're asking, you may be able to ask for documents during this hire process or the interview process. So we just wanted to make that clear, because we've had a lot of questions recently about, well, this person, I think they're on H-1B status or they're in STEM OPT. What does that mean for us? We, don't know if we want to sponsor. So just some things to think about. With the next slide, we're going to show, we just have 2 cases here out of many cases of unfair documentary practices. The first one is recent, just last year, and it's with a very well-known organization, with Microsoft. So during the course of an IER investigation, they determined that Microsoft had committed what they call unfair documentary practices against at least 6 LPRs, which is lawful permanent resident applicants based on their citizenship status during the visa evaluation process. And how they did that is that the individual had checked off that they were a permanent resident, and the Microsoft company representative asked that those individuals provide their permanent resident card. So that's a violation. It's not prohibited under law. What it resulted in was a civil penalty. And Josune and I were talking about this because the civil penalty that was listed seemed lower than what the head of IER was telling us, and maybe he got his figures mixed, but it was still a decent sum. The company was also required to update their policy with respect to I-9s and their I-9 practice. They're required to train personnel, and they're going to be monitored by IER, which means IER will check in with them to make sure that they're not continuing to do this behavior. There was another example in 2019 where IER investigated an agricultural company and found that the company was re-verifying the work authorization of lawful permanent residents, LPRs, who had already established that they have permanent authorization to work in the US. So that also resulted in a civil penalty, the training of personnel and monitoring of their processes. So it goes from large companies to small companies. It's definitely something to be aware of because it is one of the things that is on IER's radar. And a lot of these are initiated by complaints that are submitted by individuals who feel that, that they have been discriminated against or retaliated. So that's one of the things to do. So if you do have over documentation by mistake, like what do? You can, identify what forms have over documentation. You can look at them to see if there's been a pattern of this practice. You can remediate the non-compliance I-9 form. So in some instances that might be, doing edits to the form I-9. And again, we advise to do these only under guidance of an attorney or HR consultant who has expertise in this area. You also want to make sure, if you should create some kind of organization-wide non-discriminatory policy. But remember, any kind of policy you put in place, you have to make sure that you're abiding by it so that you don't get in trouble for having a policy but not doing anything with it, or doing something against it. And then the biggest thing is to provide refresher training for all hiring professionals on the I-9 process. And yes, that also means recruiters, because recruiters are going to be your front line asking questions of these applicants. And recruiters, I found, very much appreciate what questions can they ask, what should they not ask, when should they reach out to have and obtain additional guidance. So those are things to do that also will help with your I-9 audit, right? Because you want to reduce over documentation and asking for documents, which could cause a process or a problem if you're asking for re-verification documents when you shouldn't be re-verifying. So they all flow together. So the other thing with IER, which Josune is going to talk about, is one of their top 4 priorities, which they've been working on the last year, and they're going to continue on a top priority, which deals all around technology and your hiring platforms.
Yeah. So I'll go over this, relatively quickly because I do want to leave some time for questions at the end, but, it's not to make you feel bad or to make you worried or put you on edge because look, companies across the board. You would be surprised of all of the different types of, Fortune 500 companies that you would think have it together, but have these, these issues, right? Where IAR is investigating and finding critical errors. So we can go on to the next slide. So as we know, this is a priority, and IAR has reported that they've had a slew of settlements related to technology, and that's because technology can be confusing. With these job postings platforms, there's a lot of drop downs, right? You click one, and it allows you to go on to the next, requirement. So we know that this is something that can be worked on, but we also know that this is now a big target for IAR, right? And recently, they've signed 16 settlement agreements requiring private employers to pay, a hefty fine and civil penalties. Each employer posted at least one job announcement in the platform operated by Georgia Tech. So you would think Georgia Tech would have it together, right? Technology is in its name. However, they are, being somewhat practical here, but there was a drop down that asked, preferred work authorization. Well, yes, of course, right? But it caused confusion. And so they inadvertently posted unlawful discriminatory job ads. And as we've been harping on, no intent required, right? So they determined, that this, deterred, qualified students protected, under regulations because of their citizenship status. And in some cases, students were blocked from applying or meeting with company recruiters. So, it did have a poor outcome where, some students may have been blocked from applying or meeting with company recruiters. But it's important to note that, employers were just trying to hire someone, right? They just posted on Georgia Tech. However, the thing that I've discussed before is that there's a back end and then there's a front end, and those don't always coincide, right? They're not as clear. So even if you click something such as preferred work authorization, yes, let's see what the actual job posting looks like, because it's all about appearance. Is there an appearance of discrimination? Could this confuse or deter any, potential applicant who is in the protected class? And, it's problematic, right? And this was a big deal. And this wasn't the first one. We had, previous kind of platforms where IAR has seen this issue and went after them as well. This is just the most recent one. You can go down, it shows all the different employers and their fines. So, pretty hefty.
Yeah, not small by any stretch.
No, not at all. And I guess, Kimberly, I know this is a lot of information, but again, it's not to put fear in you. These are obviously, sophisticated processes that it's easy to get confused, right? And just doing a little bit of review to ensure compliance, I think, could go a long way, especially knowing that this is a huge priority. And these different types of programs have a big target on their back. So something to look at. But, can you tell us about kind of how E-Verify compares I-9 data with government records?
Yeah, so E-Verify, right, is where it's in addition to I-9, if you're enrolled in an E-Verify program, it doesn't get you out of the I-9 process. So you just want to be very careful with discrimination and E-Verify as well, in which case you don't want to selectively run workers through E-Verify based on their citizenship status, or treat workers who receive tentative non-confirmations differently based on their citizenship status. So it all goes back to citizenship status, and be fair, right? Just be fair and follow the reason. If you have to do an E-Verify for people because they're in this unit with a federal contractor, then you do the E-Verify everybody. That you shouldn't re-E-Verify people. So look at individuals that are in certain statuses or TNCs in that way where you would do that. One of the things is there is also a memorandum of understanding between E-Verify, which is USCIS, and IER, in which the E-Verify program sees that there's a pattern and practice of, you have 90 employees that checked box, the box that they're lawful permanent residents. And for 89 of those, they provided permanent resident cards. That could be a flag, which seems crazy, right? Because permanent residents are legally required to keep the green card on them at all times, but that could be considered a potential pattern and practice of an employer asking a lawful permanent resident for their permanent resident card rather than allowing them to select what document may be presented. And that's one of the main, examples in that particular process.
That was pretty shocking for me when I found that out. And I know it's a way for, IR to maybe get their foot in the door and kind of start an investigation, but especially for lawful permanent residents, it's a list A document. It's one document versus having to get maybe a list B and C. So.
Right. Well, Josune, we have a question here that I'll read, and I think we can answer this one without. It's going to go over something that we just recently talked about, but we kind of went through it quickly because there's so much. But what is the question or questions that can be asked of applicants? And then what can you ask applicants if they answer that they need sponsorship? So the question is, without stating which one, are you a U.S. citizen, non-citizen, national, lawful permanent resident, asylee, or refugee? Those are all members of protected classes for I-9 purposes. If the person says yes, you stop. If they say no, you can ask, will you now or in the future require sponsorship for employment visa status? I know it's phrased a little bit differently because it's been like telephone. In the real world, there's the question. I went back to the technical assistance letter from IER, but I know it's reworded a little bit differently for people. Where we see a lot of employers having issues with this particular question recently is for those students who are in OPT and they don't think they need sponsorship if they have STEM OPT, because in their minds, I have 3 years of work authorization and STEM OPT extension doesn't require sponsorship. So we do see employers get kind of caught in that particular situation where employees answer potential applicants answer no. We're still trying to figure out how to get around that, because if the person says no, then you take it at their face value. They don't need sponsorship. But if someone says yes, they do need sponsorship. What can you ask? Legally, you can ask questions that would allow you to determine what their current status is in order to evaluate if you as a business support sponsoring TNs, H-1Bs, or sponsorship at all. But it's all, you can ask for those documents as long as it's clear that it's for a business related reason in order to find out. So if you're like, hey, we're a small company, we're 9 employees, we don't sponsor anyone because it's a lot of money to us to do that. You can ask someone, what is your status on an H-1B? Well, how many years left? Or at that point in time, if you don't do any sponsorship, you can say, I'm sorry, we don't sponsor for positions. So it's going to be on a case by case or a company by company situation with respect to what you can ask.
And trust me, with our efforts as part of committee members, we are trying to get more concrete questions that we can ask and have determined that it is permissible and compliant. But at this time, they respectfully decline to dig any further.
I think with that, our time is up at the end of the hour. We have a couple of questions here, and we'll answer those to the individuals offline. And then when we wrap everything up, our wonderful marketing department will forward to all of you the recording and a PDF so that you have it if you want to refer back to it, or put it in the delete button, whatever works for you. We hope you refer back to it with any questions and share it with your team. So I want to wish everybody a happy holidays and to thank you all for spending an hour of your precious time with Josune and I. And Josune.
Thank you. Really appreciate it. And Hope to see y'all soon.
Take care, everyone.